Welcome, everyone, and thank you for joining us for today's presentation, Year-End 2018 Employee Benefits Update. My name is Melanie Aska. I and my colleague, Eric Sharp, will be spending the next hour updating you on recent developments in employee benefits law. Let's spend a moment or two first going through some housekeeping details. First, all participants are in listen-only mode. Next, if you have any questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will try to answer them at the end of the presentation. Last, this webinar is being recorded. All of you will receive an email after the presentation with the PowerPoint slides, a link to the webinar, and an attendance certificate. Let's begin, shall we? First, let's start with a review of the recent developments affecting hardship distribution rules for 401k and 403b plans. Plans that apply the safe harbor hardship needs provisions make hardship distributions only for the following types of expenses, which are deemed to create immediate and heavy financial needs. If we drop down in the slide to need number 1, a plan can make hardship distributions to pay medical care expenses of the participant or his spouse or tax dependents, which would be deductible under Code 213. Recently, actually very recently, on Friday, November 9th, the IRS issued some proposed regulations which would add to this list of eligible individuals the participant's primary beneficiary under the plan, which is a defined term, and that's an individual who's named as a beneficiary under the plan, who has an unconditional right when the participant dies to all or a portion of the participant's account balance. So if those regulations are finalized, then a participant's primary beneficiary under the plan, the medical expenses for such an individual could be paid for with a hardship distribution from the plan. The next safe harbor hardship need that's affected by new guidance is need number 3 toward the bottom of the slide, and that would be tuition, fees, and room and board expenses for the next 12 months of post-secondary education for the participant, his or her spouse, or tax dependents. That same set of proposed IRS regulations would also add primary beneficiary to this list of eligible individuals, and that change is proposed to become effective January 1st of this year. Next, we drop down on the slide to the 5th hardship need, safe harbor hardship need, for burial or funeral costs for the participant's deceased parent, spouse, children, or tax dependents. Again, these IRS proposed regulations would add primary beneficiary to this list of eligible individuals, also effective January 1, 2018. Next is need number 6. That is the need to pay expenses to repair damage to the participant's principal residence that would qualify for the Code Section 165 casualty loss deduction without regard to whether the loss exceeds 10% of adjusted gross income. At the end of 2017, Congress enacted the Tax Cuts and Jobs Act, which said that for taxable years 2018 through 2025, casualty loss deductions would be restricted only to those losses caused by federally declared disasters. And it was widely thought amongst the benefits community that that same restriction would carry over into hardship distribution rules for 401k and 403b plans. Well, as it turns out, the proposed regulations that the IRS issued on Friday say that hardship distribution provisions can be implemented without regard to this Tax Cuts and Jobs Act restrictions. So therefore, hardship distributions can be made to pay these sort of expenses without regard to the restriction that the Act imposed, limiting deductions only to losses caused by federally declared disasters. And then last but not least, at the bottom of this slide, there's a new proposed hardship need, which would be for expenses and losses, including loss of income incurred by participants due to federally declared disasters, provided that the principal resident of the participant or the place of employment of the participant is in a FEMA-designated individual assistance area. And these are proposed to be added to the hardship distribution rules effective January 1st of this year. On the next slide, we're going to talk about safe harbor hardship necessities. Plans that currently apply safe harbor hardship necessity rules provide that a hardship distribution will be deemed necessary to satisfy an immediate and heavy financial need only if both of the following requirements are satisfied. The first requirement is that before being able to get a hardship distribution, the participant has to first obtain all other currently available distributions and non-taxable loans under the plan and all other plans of the employer. The Bipartisan Budget Act, which was enacted earlier this year, removed that loan requirement effective for plan years beginning on or after January 1 of 2019, and the recent IRS proposed regulations mirror this. The second safe harbor necessity requirement was that the participant had to be prohibited from contributing to the plan and all other plans maintained by the employer for at least 6 months after receiving the hardship distribution. The Budget Act directed the IRS to delete this contribution suspension requirement from the 401k regulations. And the IRS proposed regulations that were issued on Friday would do that. And they would also allow plans to stop suspending contributions as of the end of this calendar year if a hardship distribution was made in the last half of 2018. So plans may but need not allow people to resume making elective contributions as early as January 1 of 2019. So that's an important change. This next slide also deals with distributions that are necessary to satisfy financial needs. The current IRS rules provide that a distribution is not going to be treated as necessary to meet an immediate and heavy financial need to the extent that that need can be relieved from other reasonably available resources. And the plan generally makes that determination based on all relevant facts and circumstances. What the IRS proposed regulations would do is they would eliminate that facts and circumstances standard and substitute a general standard which would be used for determining whether a distribution is necessary. And under that general standard, 3 different requirements would have to be met. The first is that the hardship distribution could not exceed the amount of the participant's need, which could factor in anticipated income taxes and penalties. The second requirement is that the participant would have to obtain all other available distributions under the employer's plans, but note there's, again, no requirement that the participant obtain non-taxable loans. And then the third requirement is that the participant would have to make a representation to the plan that he doesn't have sufficient cash or other liquid assets to satisfy the hardship need, and the plan would be able to rely on the participant's representation unless it had actual knowledge to the contrary. And recognizing that it's late in this year and adding this representation requirement is an administrative burden, the proposed regs would only impose this representation requirement as of January 1st of 2020. The IRS proposed regulations and the Budget Act also deal with fund sources for hardship distributions. Under the hardship distribution rules in effect prior to 2019, so that's now, the maximum amount that can be distributed on account of a hardship is limited to the participant's undistributed elective contributions and pre-1989 earnings, and then certain grandfathered QNEX and QMAX. What the Budget Act did was it expanded the fund sources available for hardship distributions to also include, and this again is for plan years beginning on or after January 1st of 2019, post-1988 earnings on elective contributions, all QNEX and earnings, all QMAX and earnings on them, and then all employer contributions to Safe Harbor 401k plans and earnings on those contributions. The proposed regulations mirror the Budget Act's expansion of the fund sources for hardship distributions, but they also clarify that if a plan wishes to, it can continue to limit the fund sources. So the expansion of fund sources for hardship distributions is not a required change, it's a possible change. There's a new bit of a wrinkle in the proposed regs for 403B plans. The preamble to the proposed regulations recognizes that the Budget Act did not change the distribution rules that apply under the code to 403B plans, and so the proposed regs clarify that earnings on 403B plan elected deferrals continue to be unavailable for hardship distribution. The proposed regulations also address plan amendments to reflect all these new rules. And the preamble to the regs say that basically if the proposed regs are finalized in the manner that they've been proposed, then plan sponsors are going to need to make plan amendments reflecting the new rules. But the regs do say that if someone is sponsoring an individually designed plan, that the plan amendment deadline would be 2 years after the publication of the final regulations in the IRS's required amendments list. So that gives you some time to amend your plan. But now is the time to be thinking about plan operations and changing plan operations and things like your hardship distribution application forms and summary plan descriptions and other employee-facing communications to reflect the new rules that you would like to put into effect for hardship distribution. One last tidbit on hardship distributions before we move on to the next topic concerns an IRS information letter. It's information letter 2018-1. The IRS issued this in January of this year to clarify that a participant cannot take a hardship distribution from his employer's 401k plan to repay the participant's child's student loans. And the rationale for that is that would not be the payment of expenses for the child's next 12 months of post-secondary education. So let's turn our attention now to plan rollover rules. So here we're going to be dealing with rolling over two kinds of items. The first is rolling over plan loan offsets. The Tax Cuts and Jobs Act, effective January 1 of 2018, extended the rollover period for participants who receive plan distributions on account of termination of employment or plan termination. And if the distribution includes a plan loan offset amount, under the old rules, the participant only had 60 days to come up with funds from another source to roll over those funds on a tax-free basis into another plan or IRA that would accept them. And what the Tax Cuts and Jobs Act did was, effective for January 1 of 28, it extended that rollover period so that, for example, if I terminate employment under my 401k plan and I have a $100,000 plan account balance, and I get a 1099-R for $100,000 of distributions, but that distribution includes a $20,000 plan loan offset amount, and say this all happens this year, under these rules, I have until my federal income tax filing deadline in 2019, including any extensions, to find the $20,000 from another source and roll that over into a plan or an IRA that will accept that rollover. The second bit of rollover news has to do with rolling over refunds of tax levy distributions. The IRS, if you owe taxes to the IRS, it can levy against your plan account, for example, your 401k plan account, to satisfy your tax liabilities. So let's just say, for example, the IRS levies against my 401k plan account, and a levy distribution is made from that account, and then the IRS discovers that levy was improper. Let's just say it's discovered that I don't owe those taxes. So the levy was improper, and the levy distribution was unnecessary, and the IRS then pays me a refund. Under these rules, once I get that refund, I have until my tax return due date for the year that the refund occurred, without extensions, to roll that refund amount that either back into the plan from which the tax levy distribution was made, or to another plan that would accept the rollover. So these are all favorable rollover changes. The next topic that we're going to be dealing with is a change in the tax treatment of moving expenses. The Tax Cuts and Job Act, and then a subsequent IRS notice that was issued in September, basically state that moving expenses that were incurred during taxable years 2018 through 2025 and that are either paid or reimbursed by the employer, those payments or reimbursements by the employer will be taxable wages. And you may ask, how does that affect retirement plans? Well, that change affects retirement plans in the following ways. First, every qualified retirement plan, for example, has a definition of Code 415 compensation, which is part of the limitation that applies to either annual additions under a defined contribution plan or annual benefits under a defined benefit plan. Code Section 415 compensation is taxable compensation, and so if you have a participant in any of these tax years that receives taxable payments or reimbursements of moving expenses, then those payments or reimbursements need to be included in the person's 415 compensation. So both your plan operations and ultimately your plan document are going to have to catch up the plan's 415 compensation definition to reflect that such compensation includes taxable payments or reimbursements of moving expenses. The second area where this can become relevant is the definition of compensation that the plan uses to determine benefits. So, for example, if you have a definition of compensation that is not intended to include things like taxable moving expenses, you're going to need to make sure that both in operations and in your plan document affirmatively excludes taxable moving expense payments or reimbursements so that you don't inadvertently provide benefits on the basis of a piece of compensation that you intended to exclude. The next bit of information that we want to share to you has to do with plan forfeitures. There's been a change in the law that says that plan forfeitures can be used to fund 401k plan QNEX or QMAX. Just as background, employers can make qualified non-elective contributions, or QNEX, or qualified matching contributions, also known as QMAX, to either help them pass the ADP and ACT non-discrimination tests under non-safe harbor plans, or they can use QNEX or QMAX to meet safe harbor employer contribution requirements under safe harbor plans. So under prior law, a QNEC or a QMAC had to be 100% vested when first contributed to the plan. And so under that rule, forfeitures could not be used to fund QNECs or QMACs because forfeitures, by their very nature, are not vested when they arise under the plan. But under final regulations that the IRS issued back in July of this year, and that are applicable both retroactively and prospectively, QNECs and QMACs do not have to be 100% vested when contributed to the plan. They only need to be 100% vested when they're actually allocated to participants' accounts. So that change in the definition of QNECs and QMACs means that employers can use forfeitures, plan forfeitures, to fund either QNECs or QMACs, making them easier to afford in many cases. So there again, this is just a change that you want to reflect. If you want to take advantage of this change in the law, you would want to make sure that your plan operations and your plan document are both changed to conform to this new rule. Next, we want to consider a brand new feature that one employer, we believe it's Abbott Labs, went into the IRS and requested a private letter ruling from the IRS on a student loan repayment benefit, which Abbott Labs added to its 401k plan. And that student loan repayment benefit has the following key features. First, an employee who made a student loan repayment outside of the 401k plan equal to or greater than 2% of pay each pay period would receive in the plan what's called an SLR non-elective employer contribution equal to 5% of pay. And that SLR non-elective employer contribution would be made whether or not the employee made elective deferrals to the 401k plan. It also would be subject to all applicable plan qualification requirements such as eligibility and vesting and distribution and all the rest. And it would not violate the contingent benefit prohibition because that contribution would not be conditioned either directly or indirectly on the employee making a 401k elective contribution. And then there was a further feature to this arrangement, which basically provided that an employee who did not make a student loan repayment equal to or greater than 2% of pay outside the plan, but who did make elective contributions equal to or greater than 2% of pay to the plan would receive a true-up matching contribution in the 401k plan equal to 5% of pay. So here again, this is a planned feature to consider, possibly adding to your 401k if you have a workforce that has a lot of student debt. But one word of caution, just remember that this feature was blessed by the IRS in a private letter ruling, which only applies to the employer who requested the ruling. It can't be generally applied. So if you want to go ahead with a feature like this in your own 401k plan, at least consider applying for your own private letter ruling unless and until the IRS issues more generally applicable guidance allowing this sort of feature under all 401k plans. All right, moving on to rollover notices. Code Section 402F requires qualified plans and tax-sheltered annuity plans and governmental 457B plans to provide rollover notices to anyone who receives an eligible rollover distribution from any of those kinds of plans. And from time to time, the IRS updates its safe harbor rollover notices. It issues two safe harbor rollover notices, one for distributions coming out of non-Roth accounts, and a second for distributions coming out of Roth accounts. The last time the IRS updated its two safe harbor rollover notices was back in December of 2014, and obviously the law has changed a bit since then. So, that being the case, in mid-September, the IRS issued a notice 2018-74, which contains two updated safe harbor rollover notices which reflect all of the law changes in the world of rollovers that have occurred since December 8th of 2014. And the bottom line here is you'll need to start using these new safe harbor notices. If you choose to use a safe harbor notice, which you may but are not required to do, but I think it's advisable to use safe harbor notices. If you do use safe harbor rollover notices, please be sure to begin using these new safe harbor updated notices right away. They needed to be used beginning on or after September 8th of this year. Next, we want to tell you about some updates to the IRS's plan correction programs. As you probably know, the IRS issues guidance, and it's called the Employee Plans Compliance Resolution System, or EPCRS. And what that is, it's a collection of correction programs that allows plan sponsors to correct all sorts of plan document or operational or other failures in their plans. And from time to time, the IRS updates the revenue procedure that is the source of this EPCRS guidance. And the IRS very recently, at the end of September, issued an updated EPCRS revenue procedure. It's Revenue Procedure 2018-52. And the newest part, the most significant update in that revenue procedure are the changes that apply to the voluntary correction program procedures. And what those changes basically say is that effective April 1st of 2019, all VCP submissions must be filed electronically with the IRS, and all of the VCP user fees also must be paid electronically using an IRS website. There's a transition period which begins January 1st of 2019 and goes until the end of March 2019, where if you want to make a VCP submission, you can either make the submission on paper and pay with a paper check, but that transition period ends at the end of March, and so therefore as of April 1 of next year, if you're going to do a VCP submission, you must make the submission and file the fee electronically, or else the IRS will return the application. Somewhat relatedly, earlier this year, the IRS updated its schedule of VCP user fees. Before this guidance came out at the beginning of 2018, VCP user fees were determined essentially on the basis of a participant head count, and there were some exceptions for special situations that basically produced lower VCP fees than the participant head count would yield under the fee schedule. The IRS did away with all of that at the beginning of 2018 and now computes VCP submission fees based only on a plan's total net assets. And we set the fee schedule out there for you on the slide so you can see what VCP user fee would apply to your plan based on its net assets. One other bit of information from the IRS is that earlier this year, the IRS made a request for public comments on whether it should revive to any extent its determination letter program for individually designed plans. As you probably know, back in 2016, the IRS issued guidance that said if you sponsor an individually designed qualified plan, you can get a determination letter from the IRS only upon the plan's initial qualification or on its termination, and unless the IRS issues other guidance in the future, you can't get a determination letter during the life of the plan. And a lot of practitioners are not happy with that because obviously things happen to plans during their lives, including they merge or they get amended or they're involved in corporate transactions, and plan sponsors want the comfort of an IRS determination letter during the life of the plan. So the IRS has heard those comments and it's now requesting more comments on whether it should expand its determination letter program in some way for individually designed plans. Next, we have a chart of some selected updates to the 2019 retirement plan dollar limits, which the IRS recently announced on November 1st. We've only selected a few of them. Those updates came out from the IRS in the form of Notice 2018-83. In that notice, you'll see all of the updates. So we've only selected a few important ones here. For example, most notably at the very top, the dollar limit for elective deferrals has gone up slightly from $18,500 to $19,000 in 2019. The next limit, the age 50 catch-up limit, is the only limit in this chart that didn't change. That remains at $6,000, and you can review the rest of the limit changes on your own. Also note at the very end, we've added the update to the Social Security taxable wage base. It too increased slightly from 2018 to 2019. Last but not least, I have the next three slides basically just give you an update of the annual notices to participants that you might need to provide by generally December 1st for next year if you're sponsoring a 401A defined contribution plan that has that's a safe harbor plan or has any of these qualified contribution arrangements like the qualified automatic contribution arrangement, etc. I won't go through the details on this, but again, because of the timing of this seminar, it's nearing year end, this is a good time to give you all a heads up, a timely heads up on these annual notice requirements. So at your leisure, peruse this slide and the next and the next so you can refresh yourselves on the annual notices that you need to furnish to your participants generally by December 1st of this year for next year. And with that, I'm going to turn the program over to my colleague, Eric Sharp.
Thanks, Mel. And I want to just quickly acknowledge my colleague Melanie, who did a phenomenal job with the slide deck, and it's very comprehensive and very well drafted. She made my job today much easier, so thank you. I appreciate it. And so we'll jump in, and while Mel is a resident here in our Boston office, we're in Boston today. I am in New Haven, and I would want to point out that there are a lot of technical issues that we have in our practice anyway, but that we're also sort of communicating to you today. And to the extent you have any questions at all, none too small, none too complex, please feel free to either email or call either one of us, and we're happy to work with you. So I will jump in. As many of you may have heard about, or some of you may have heard about, or perhaps none of you may have heard about, there are new Department of Labor disability claim procedures that were finalized earlier this year with an effective date of April 1, 2018, and really come into play with regard to disability claims made under whether it's a retirement plan or a health and welfare plan. Disability claims that arise after April 1, 2018. What is a disability claim? Essentially, if you take a look at your 401k plan, you may have a disability benefit in there which says that an individual can get their benefit that either vests and it becomes distributable, or it simply becomes distributable if it's already vested, at a date that may otherwise normally would be able to get it. So take a look, I would suggest you take a look procedurally through your retirement plan benefits if you're not sure, and see, does my plan discuss disability? If it does, then you need to take a look at whether or not the determinations of disability, whether a participant is in fact disabled, are discretionary or non-discretionary. Now, what does that mean? The plan administrator, if the plan administrator for your plan essentially has the ability to, or is saddled with the obligation to determine whether a participant is in fact disabled, so the participant makes a claim, and then it's on the plan administrator, generally through farming it out to a medical professional or a vocational professional that is designated by the plan administrator, then that's a discretionary determination by the plan administrator. If the plan administrator, per the terms of the plan, is directed to look to whether the participant has been determined to be disabled based on the terms, what it means to be disabled under a long-term disability plan, or if the Social Security Administration has made the determination that the individual is disabled, then that's a non-discretionary standard. The plan administrator is handcuffed by a determination of disability made by a third party. Why is that important? Well, the Department of Labor has said that if the plan provides for a discretionary determination of disability, so the plan administrator has the obligation to determine whether the participant is disabled, there are heightened disclosure and procedural requirements that come along with that responsibility. And you'll see these baked into, sometimes they're baked into your plan document itself. They have to be baked into your summary plan description that goes to participants and beneficiaries. But they are claims procedures, claims review procedures, and they're often, well, not often, they're always sort of bifurcated between the initial claim for benefits, both on a non-disability basis and a disability basis, and an appeals process, again, on a non-disability claim basis and a disability claim basis. So if you have a plan administrator that has discretion to determine disability, there are new components, and the Department of Labor has said that the following now have to be adhered to, and this is a selection because they are rather lengthy in the regulations. Disability claim denial notices must now contain a number of new elements, including an explanation as to why the plan disagreed with the views of the healthcare or vocational professional who evaluated the claimant or advised the plan, or a disability determination of the Social Security Administration. If you are, they have to either contain either specific internal rules, guidelines, protocol standards, or other similar criteria to the plan that were relied upon in denying the claim, or alternatively a statement that such rules, guidelines, protocol standards do not exist. and a statement that the claimant is entitled to receive upon request and free of charge reasonable access to copies of all documents, records, and other information relevant to the claim. Denial notices must, in certain circumstances, be provided in a culturally and linguistically appropriate manner. I think that this was something that was somewhat unexpected, though I think given sort of where we are now, it can't be totally unexpected. So what does that mean? If a claimant's address is in a county where 10% of the population are literate only in the same non-English language, then the notices have to be provided in that language. And so I would really express to you that if this is something that you're concerned about, we should have a discussion about how to discharge that obligation. A plan's decisions regarding hiring, compensation, termination, promotion, or other similar matters with respect to any individual who makes the determination, a medical professional, a vocational professional, a claims adjudicator, must not be made based upon the likelihood that the individual will support a decision denying a benefit claim. So you can't pay for certain claims determinations, denials, essentially. Disability benefit claimants have to be given an extended period of time to appeal a denial decision now. Before a plan can deny a claim appeal, the plan administrator must provide the claimant free of charge any new or additional evidence considered, relied upon, or generated by the plan, the insurer, or the person making the benefit determination. And then, except with respect to certain de minimis violations that occur, if a plan fails to, so if you plan administrator are subject to these new disability determination rules, and you fail to strictly adhere to the new claims procedures, both in operation and essentially baking them into the document, whether it's your plan document or your summary plan description, or both, as necessary, the claimant is deemed to have exhausted the administrative remedies available under the plan and may proceed directly to litigation under ERISA. This does not mean that the court will, as a matter of course, grant the determination that the person is disabled, but it will allow them to move outside of the administrative remedy in the plan, which they otherwise would have to exhaust before moving to litigation. So what does this mean, practically speaking? Take a look at your documents. Make a determination first as to whether you in fact have disability benefits under your plan. And if you do, or if you are not sure, please reach out to Mellorai. We can help you navigate that. If you've already got a non-discretionary standard, there may be changes that are required to the language to simply remove the old disability claims process language and utilize the non-disability claims. And it gives you a chance anyway to review your claims language and make sure it's where it needs to be. If you have a discretionary standard, then we need to talk about any amendments that are necessary to bring your documents into compliance, and then to also operationally renew the plan administrator into compliance with how these claims are being administered. With that, I will move to the next topic. The Department of Labor also, and this has been a multi-year issue, starting back in 2016, the Department of Labor had issued a fiduciary rule, which was intended to basically greatly expand the net that was cast over service providers who were providing certain types of investment-related services to plan sponsors, and became known as the fiduciary rule, and it became very contentious, and it has since been vacated. A lot of work was done to implement this in practice, and so even though there has been a vacator through the courts, it's worth noting that a number of service providers who would be picked up as fiduciaries under this rule have maintained the operational changes as a result of this rule. But what are we talking about here? So ERISA has a fiduciary definition. It's been in existence since 1975, and it includes anyone who for a fee provides investment advice with respect to plan assets. The 1975 rule, which is still the current rule, was based on regulations that limit fiduciary status based on a 5-part test. So a fiduciary would be, a service provider would be a fiduciary to the extent they were rendering investment advice or a fee to persons who, on a regular basis, rendered individual advice that was the primary basis for participants' investment decisions, 5-part test. 2016, the Department of Labor issued these regulations and eliminated the regular basis and primary basis criteria, and thereby expanded the fiduciary definition, making it more likely to apply to a broader pool of service providers that otherwise had not been caught up under the fiduciary definition, as well as to retirement-based products that otherwise had generally fallen outside into IRAs and HSAs. There were certain prohibited transaction exemptions that the Department of Labor issued in conjunction with these new rules that imposed impartial conduct standards and sought to clarify the application of the fiduciary rule to a myriad of different types of service providers and service and retirement-related products. Parts of the 2016 fiduciary rule became applicable in June of 2017 with some transition relief. And as a result of that, you saw a number of these large service providers, the Fidelities, the Vanguards, the Schwabs, who were implementing these at a very fast clip in order to come into compliance. There was still a lot of pushback from the industry, and it wasn't going to be workable. And so it went to litigation. The fiduciary rule was officially vacated earlier this year. In June, the Fifth Circuit Court of Appeals finalized a judgment vacating the 2016 fiduciary rule and the related prohibited transaction exemptions. And so now we are essentially back at the 1975 fiduciary standard. And again, that is that 5-part test. So again, a person who provides investment or advice for a fee is not considered a fiduciary under ERISA unless they satisfy the following 5 elements. Again, must render advice as to value of securities or other property, or the advisability of investing in, purchasing, or selling securities or other property on a regular basis, pursuant to a mutual understanding with the ERISA client that the advice will serve as a primary basis for the ERISA client's investment decisions, and that the advice will be individualized based on the needs of the ERISA client. So there is some movement in the way of a regulation best interest that the SEC has proposed. Now, there has always been some inherent tension between the SEC and the Department of Labor in how they were going to both issue and apply a fiduciary standard that would be workable under both their statutory and regulatory schemes. As you can imagine, investment folks who were rendering fiduciaries who were rendering investment advice to plans were also often caught up under the SEC governance requirements. So the SEC has now decided to take a crack, and they have this proposed regulation best interest. I won't get into the weeds too deeply here, but it's generally the creation of an express standard of conduct that requires broker-dealers to act in the retail customer's best interest, not to place their financial or other interests ahead of the customers. It tracks in some respects the best interest contract exemption that was under the fiduciary rule, which was sort of the queen bee portion of the 2016 fiduciary rule from the DOL. But arguably there's a reduced standard of care here under the SEC's regulation best interest, and there are less extensive disclosure obligations. Notably, it does not really tie broker-dealers' hands based on their receipt of the remuneration. And so we will wait to see sort of how that plays out as the SEC goes through and collects comments and determines whether to finalize these regulation best interest rules or move in a slightly different direction. Next, I'll talk briefly about this The DOL has addressed fiduciary standards on economically targeted investments and shareholder activities, so shareholder activism, through the release of Field Assistance Bulletin 2018-01, which was released in April of this year. It directs the FAB directs the Department of Labor's regional offices on how to interpret previous DOL guidance, which was Interpretive Bulletin 2015-01, which related to the extent ERISA plan fiduciaries can take environmental, social, or governance factors into account when making economically targeted investments. And then in Interpretive Bulletin 2016-01, which related to an ERISA plan's exercise of shareholder rights and written investment policy statements. So dealing first with, and quickly with economically targeted investing, the new Field Assistance Bulletin, the Department of Labor acknowledges that economically targeted investing, this is also sometimes known as socially conscious investing, factors can be investment, quote-unquote, tiebreakers, but cautions plan fiduciaries against readily converting these ETI factors into relevant investment return economic factors. What does all that mean? It's kind of a mouthful, right? Essentially means that you can look at those economically targeted investment factors in a collateral fashion, but in making a determination with regard to whether an investment is appropriate for a plan, the plan fiduciary still must focus primarily on risk and return for that plan. So it has to take a look at what is best for the plan participants and beneficiaries, what is prudent, and essentially exercise their traditional ERISA fiduciary obligations in choosing the investments. So tiebreaker, right? So you've got two separate investments and they are remarkably similar with regard to risk and return characteristics, and one of them has economically targeted investment strategies that are more appealing to the plan fiduciary, and the plan fiduciary can then factor that in as a collateral interest, a collateral factor in determining which of the two investments to ultimately utilize in the plan's portfolio. What it means essentially at 30,000-foot level is you cannot subvert risk and return and traditional ERISA fiduciary obligations to socially conscious factors, to economically targeted investment factors. Investment policy statements, the Field Assistance Bulletin issued by the Department of Labor states that although an investment policy statement may but not contain these ESG investment guidelines, fiduciaries can adhere to those guidelines if they are in an investment policy statement, but they need not do so if they are otherwise imprudent or otherwise violate ERISA. And look, this ideal is really embodied in ERISA fiduciary law anyway. So to the extent that fiduciaries are generally required to follow the terms of plan documents, except to the extent the fiduciary makes a determination that the directive in the plan document is imprudent, otherwise violates ERISA's fiduciary standards. This follows suit within these investment policy statements that contain these ESG, environmental, social, or governance factors, and investment guidelines. The other point to make here is that to the extent you have an investment policy statement, if you have a guideline or a directive in that investment policy statement, it should be one that you are looking to follow on a regular, routine basis. If you are not, you need to document why you are not, and then it's crucial that you take a look as to whether or not the ESG factors or any other part of the investment policy statement continues to be relevant to the investment directives that are being utilized by the plan. The Department of Labor takes a very dim view of plan administrators, sponsors that maintain investment policy statements that have irrelevant or contrary directives in them. So next slide again. the FAB 2018-01 states that a prudently selected, well-managed, and properly diversified ESG-themed investment alternative could be added to a K plan or other individual account plan's investment platform, but discourages the use of these themed investment alternatives as QDIAs, qualified default investment alternatives, because you can read through the bullets here, but generally you see these QDIAs as investment defaults under a plan whereby a participant may not have communicated certain elections, so their money is going in. To the extent you have these ESG funds, the Department of Labor has essentially said, we don't think that they're appropriate for using in this QDI fashion because they are default investments. The next bullet really talks about shareholder engagement activities. If anybody listening, routinely as a fiduciary gets into shareholder activism with regard to the investment of plan assets, again, this is something that you should really discuss with Melanie and I, because there are inherent tensions with the ERISA fiduciary rules, and we should talk about what the obligations are on a going forward basis, given the new Department of Labor guidance. So I'm going to move quickly into the ERISA plan governance structure, fiduciary best practices, and we're going to skip over, we'll skip over for right now the multi-employer retirement plan part of this, because I think, given the time, and I want to try and get you folks out of here in the hour, but we'll move into the ERISA plan governance structure, fiduciary best practices. Again, really quickly, ERISA plan fiduciaries include not only the named fiduciaries in your plan document, but also functional fiduciaries. So that is anyone who is exercising fiduciary duties under the plan, whether or not they're named as a plan fiduciary. That's critical. It's anyone who exercises discretion over plan management or any authority over plan assets, who renders investment advice for a fee or other comp directly or indirectly, and has discretion over plan administration. So whether you're handling dollars at all plan assets, if you have discretion over plan administration, you're a fiduciary for purposes of ERISA. And again, this assumes that you're a plan governed by ERISA. If you're a governmental plan, you can breathe a little easier, at least in terms of ERISA. You are still subject to fiduciary obligations. That's another discussion that we should have off topic here, and I would invite you to call Mel and I. But these are largely facts and circumstances-based tests. What duties are being performed will determine your fiduciary status. If you're a named fiduciary, guess what? You are a fiduciary. ERISA fiduciary duties, I've talked a bit about them, and so I'll digress for a moment. What are they? There's a duty of loyalty. Fiduciaries have to act in the best interest of participants and beneficiaries. There's a duty of exclusive benefit. Fiduciaries must act for the exclusive purpose of providing benefits to plan participants and beneficiaries while defraying reasonable expenses of administering the plan. There's a duty of prudence. Must act with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent person acting in a like capacity and familiar with such matters would act. This is a heightened standard, folks. So if you are a fiduciary, you are deemed to be a prudent expert. It is a tough standard to meet, and one that has to be taken seriously. There is a fiduciary duty that involves diversification. Fiduciaries must ensure that plan assets are well diversified to avoid large losses. You often see this when in a 401k plan, when you are with your service provider constructing an investment portfolio, designated investment alternatives. You are looking at offering, let's say, mutual funds that run the spectrum from a bond fund to an aggressive fund to something that is targeted to the S&P. There is an exception here for ESOPs, which are intended to invest primarily in employer stock. If you have an ESOP and you have questions about this and your duties of diversity, call us. I'm happy to talk with you about this, as I'm sure Mel is. There's also, as I mentioned earlier, a duty to fiduciaries must follow the terms of the plan documents and other documents governing the plan unless they are inconsistent with ERISA. It's key here, and I want to point out that this isn't just your plan document. So if you are running a volume submitter plan or a prototype plan, this is not just the basic plan document and your adoption agreement. There are other plan documents. There's a trust agreement. There is a summary plan description. There is an investment policy statement that I mentioned earlier. There are amendments to all of these documents. So to the extent that you have all of these documents in place, you need to be cognizant of what they say and that they are harmonized to the extent they need to be harmonized. So I'll quickly here run through 4 best practices of the core of good fiduciary governance, which constitute the essential elements of operating a retirement plan. Have committees, have well-organized and staffed fiduciary committees. I understand that not every plan sponsor is of the size that they can have multi-person committees. To the extent you can do this, have well-organized and staffed fiduciary committees. What does that mean? Appoint people to your committees who bring certain levels of expertise or experience to the table. Staff them with quote-unquote experts. This means that you must carefully evaluate and select the members because that in itself is a fiduciary act. Select and monitor the plan investments. Set the plan's overall investment objectives and strategies. Investment policy statement. If you have one, set it in the investment policy statement, follow it, or amend it. Select the appropriate investments. Regularly monitor the investment performance. I can't emphasize this. You don't get to just choose the investments and then be done, wash your hands of your fiduciary obligations. You have a duty to monitor, and monitor not only the investments that are in the portfolio, but the service providers and the consultants. And if you have an independent fiduciary who is giving you advice with regard to the investments, an IA, an investment advisor, a registered investment advisor, you need to monitor all of those elements to make sure that ERISA fiduciary obligations are being discharged for the benefit of your participants and beneficiaries. Add or remove investments when warranted. You'll often see watch lists of underperforming investments or investments that are not performing in a manner that is expected, and remove them if necessary in accordance with plan policies. And this is extremely important. You cannot delegate away all these fiduciary obligations to a platform advisor, a consultant, or an RIA. It doesn't work that way. Plan costs. Ensure the plan administrative costs are appropriately allocated between the employer and the plan, and that all costs incurred by the plan and paid from plan assets are reasonable. And take a moment every couple of years at least to evaluate the cost and expenses that you're paying for administrative services, for fiduciary services to the extent you're using outside third-party service providers. Use RFPs, request for proposals, get multiple proposals in, and take a look at what the fee structures are coming in from these various service providers. It may be necessary to take a look at whether a change is necessary. It may not be, and under ERISA, you are not required to choose the lowest cost alternative every time, but you need to get these RFPs in. You need to take a look at cost structures, administrative structures, and then document why you're making choices. And again, this is something that Mel and I can work with you on and explain in greater detail. Plan administration, oversee the creation of plan documents, ensure the plan operates strictly in accordance with those documents and satisfy all applicable compliance requirements. Work with counsel on this, especially the operational compliance of the documentary compliance requirements. There are periodic amendments that have to be made to plan documents and periodic revisions that need to be made to documents that get disclosed to participants so that everything is harmonized. The other thing I just want to note here, in discharging the fiduciary best practices, it is crucial to document governance processes. RFP implementation proposals and agreements from service providers, minutes, notes from internal fiduciary deliberations and discussions, reasons why fiduciary decisions are being made, etc. Document everything. And don't deviate. If you've made decisions on a fiduciary level with regard to how the plan is going to be maintained, operated, how investments are going to be utilized, what investments are going to be utilized, how assets are going to be invested in what percentages. Don't simply make decisions and then deviate from them on a going forward basis. Reevaluate if necessary. Hold interim meetings if you need to do that and document why changes are being made. Keep these minutes, keep these notes. Final page here. ERISA fiduciary best practices when organizing committees. We talked about this briefly. Appoint a fiduciary committee. Have a clear appointment process of one or more committees. Specify each committee's relationship with the employer's board of directors, officers, and executive management team. This really important because oftentimes you're creating these committees as a way to insulate boards of directors, officers, and executive management in making fiduciary decisions because they may simply not have that expertise. Again, and I fully recognize here, as does Mel, that with smaller employers, it often is the board of directors, or it often is the officers, the CEO, the CFO, who are making these decisions out of necessity. So, certainly we can have a discussion with you about discharging these responsibly, these fiduciary obligations. Reevaluate the committee membership periodically, make sure that the folks who are on the committee continue to be the best selections for the committee, and reappoint if you need to reappoint. Committee structure and meetings, determine the structure of each committee, size, membership, what are their designated responsibilities. Let the folks on the fiduciary committee know what they are responsible for deciding. And the frequency of the meetings, memorialize all of this in a document. More often you see it in the committee charter. Give each member of the committee a copy of the charter so they understand what their obligations, what their role is or are. And then the qualification and training of committee members. Again, this goes to the ongoing duty to discharge fiduciary obligations. Make sure that the appointed members are provided appropriate ongoing training. Should always seem to be necessary. Make sure fiduciaries are apprised of new developments, requirements in the law, and work closely with counsel and third-party service providers to make sure that everybody was on the same page. There's nothing more frustrating from both a plan sponsor and a committee and counsel and a service provider perspective as when we're sort of working across purposes and people aren't on the same page. Documentation. Plan document or committee charter should define each committee structure and responsibilities. We touched on that earlier. Each committee meeting should be documented with minutes to be reviewed and approved by the committee. And when you document, take it seriously. I would err on the side of making it over-inclusive. And then, reviewing based on those, the minutes of the actual documentation during the meeting and fine-tuning for approval. But make sure that once you have minutes in place, a copy goes with your plan documents, as well as with your general corporate documents, and give a copy to the members of the fiduciary committee so that they can reference it if necessary. So thank you. I appreciate your time. And again, Mel and I are here and available. Mel is here in Boston. I'm in New Haven. We work seamlessly, so feel free to call either one of us, and we can take your questions and have a discussion.
Okay.
Do these hardship needs apply to 401A plans as well?
To governmental 401A plans as a general rule, yeah.
Yeah. Mm-hmm. Because these are rules that go to the tax qualification of the plan. These are not ERISA-based rules, so
Right.
so they would apply to 401A governmental plans that are permitting hardship distribution.
Right, and it's important to note that not all plans provide for hardship distributions. Right. It's not mandatory. It's an election that a plan sponsor makes when they are implementing their plan or that you can amend into your plan.
Do we have any other questions? That's it. Okay, well, that concludes our program today, and we hope that you found the information that we've given you in speaking and in the slides helpful. Just to repeat, all of you are going to be receiving an email after the presentation is over with the PowerPoint slides. You'll also get a link to the webinar and an attendance certificate. So be watching your email inbox for that. If you have any additional questions, as we've mentioned during the presentation, please feel free to reach out to Eric or to myself, and we'll help you in any way we can. So it's been a pleasure being on the webinar with you, Eric, and sharing the new developments with people on the line. So thank you very much for your attendance, and we hope to see you again in the future.